Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with an update on the Northern District of Illinois case against R. Kelly, Derrell McDavid, and Milton Brown. And so, as expected, they are looking to change the hearing date. They're saying that they cannot move forward with the October 13th date that was previously established. And so, before we get into the motion that was filed today, there was a status hearing last week on August 4th. And I guess a lot didn't happen with that. Basically, there was a docket entry that was entered that basically stated that there was a telephone status conference held and continued to August 18th at 10 o'clock a.m. With only the attorneys. The government shall respond to Robert Kelly's motion for disclosure and protective order on or before August 11th, which is tomorrow, and that Mr. Kelly shall reply on or before August 18th, 2020, and they're saying that there was a notice that was mailed, so not really sure what all that is about, but I'm thinking Greenberg and crew probably are still trying to get information on any of the people who are, still haven't been named to them. So they're looking for disclosure information. And then in the motion that was filed today, it's a government's motion to continue trial. And it says, based on the discussion that occurred at the status hearing on August 4th, 2020, the government respectfully moves to continue the trial date of October 13th, 2020, and to exclude time under the Speedy Trial Act to the new trial date. In support of this motion, the government states as follows. One, trial in this case is currently scheduled to begin on October 13th, 2020. The government has notified the court that it expects the trial to last approximately 3 weeks. 2, this is currently a public health emergency arising from the COVID-19 pandemic as recognized by the Fifth Amended General Order 20-0012 of the United States District Courts for the Northern District of Illinois. The government estimates that it will call approximately 50, that's 50, witnesses at trial. Of those witnesses, approximately 12 to 13 of them, including 2 victims, live out of state and would need to travel to Chicago for trial. 4, according to the city of Chicago, there is an emergency travel order that requires travelers from certain states to quarantine themselves for 14 days when they arrive in Chicago. Currently, of our out-of-state witnesses, approximately 8 to 9 of them would be traveling from states listed on Chicago's quarantine list. 5. In addition, a number of the government's witnesses are in high-risk categories for developing a severe illness if exposed to COVID-19, or they live with such individuals. Attached to the motion is an under seal exhibit that identifies these witnesses and their high-risk conditions. Forcing these witnesses to risk their health or the health of their families is not something the government wishes to do. However, you guys are willing to risk Mr. Kelly's health by holding him. I'm not going to say this about the Northern District of Illinois because they seem to be willing to let him leave, but the Eastern District of New York is really the ones that's keeping him detained. So, number 6, go back up. Counsel for defendant Mr. Kelly indicated at the status hearing on August 4th, 2020, that he is facing challenges in preparing for trial because he cannot have in-person meetings with Kelly at the Chicago MCC. Moreover, counsel for Kelly indicated that because of Kelly's limited ability to read and write, the social distancing requirements in the courtroom would limit his ability to communicate effectively with his client because they cannot communicate in writing. 7. Counsel for Kelly stated at the status hearing on August 4th, 2020, that the trial in New York, currently scheduled for September 29th, 2020, would likely run long and overlap with the trial in Chicago. According to a jointly submitted jury questionnaire in the New York case, the parties in that case estimate that their trial will last approximately 4 weeks. Then they give the docket number and information. It says a 4-week trial in New York beginning on September 29, 2020, with overlap with the Chicago trial on October 13, 2020. 8. The COVID-19 pandemic causes additional challenges relating to jury selection, especially for this particular trial. Defendant is a well-known celebrity, and Chicago is his hometown. There has been a lot of publicity about the case that may require the calling of a larger veneer than is usually called to seat a jury. Given the length and nature of the trial, a larger number of alternate jurors may be needed. This trial is anticipated to last 3 weeks, and this projected length of the trial may have an impact on the number of individuals who may need to receive summonses and who may need to be excused for cause. This trial involves allegations of abuse of minors, and this too may create a higher than normal number of excusals for cause. These challenges relating to jury selection may lengthen the trial because of the need to socially distance and protect the health of the potential jurors. 9. The COVID-19 pandemic also causes challenges relating to setting up a courtroom for a large 3-defendant, 3-week trial. Given the number of defendants and counsel in this case, at least 4 counsel tables will be needed, with possibly an extra overflow table for additional counsel. The jury will likely consist of 15 jurors, the regular 12 and 3 alternates, who will each need their own juror station that is socially distanced from one another. Each counsel table and each juror station will need to be separately wired to be able to view exhibits. Setting up a courtroom in these circumstances will be very difficult, and socially distancing during this trial will be especially difficult given that there will be at least approximately 34 to 36 people in the courtroom at a time, not counting spectators. Continuing the trial will allow the court systems to work out these difficult issues by conducting smaller and shorter trials, first to minimize the risk of disruptions to a larger trial, which could result in a mistrial and having to retry the case. Because the case will involve the testimony of at least 7 victims of abuse, it is particularly critical that this trial happen only once so as to not re-traumatize the victims. Now, I don't understand how they have 7 victims, but there's only 4 or 5 people on the indictment. Are they adding some extra people? Or are they planning to bring in some people that are not actually associated with the trial, but who will be testifying, sort of like what they did in the Bill Cosby and the Harvey Weinstein cases? Not sure here. Number 10, for all of the foregoing reasons, the government respectfully requests that the trial be continued and that time be excluded under the Speedy Trial Act to the new trial date. See Title 18 United States Code, Section 3161. Specifically, the following provisions of the Speedy Trial Act Section 3161H3B, delay resulting from the absence or unavailability of essential witnesses. The ends of the justice served by the exclusion of time outweigh the interests of the parties and the public in a speedy trial, given the need to protect the health and safety of defendants, defense counsel, prosecutors, court staff, jurors, and the public. Delay resulting from trial with respect to other charges against the defendant. Then they cite the New York trial overlapping. Delay resulting from transportation of any defendant from another district. And once again, they talk about the New York trial. And I guess because they're requesting to change the date, that resets the request for a speedy trial. Because I'm thinking at this point, they have already kind of made the speedy trial null and void, because remember, the case was originally supposed to go to trial in April. And so that's when Derrell McDavid said he wanted to separate. Well, actually, it was supposed to go the end of last year when Derrell McDavid said he wanted to separate himself. And then he had like a couple of months to respond. They didn't respond. And so that meant that he waived his rights to a speedy trial. And the trial was supposed to start in April. But then, COVID happened. And so they pushed it out to October. And so maybe each time they change the date, they have to go through the whole speedy trial process again. So then there was something else up here in the notes section, and let me see if that's something of importance. It says these jurisdictions. Okay, so they're talking about the jurisdictions. Oh, and then just talking about the number of people that would be participating in the case. So let's go on to number 11. It says Defendant Kelly is the only defendant in custody. Defendants McDavid and Brown were released on bond conditions. Then number 12, at the status hearing on August 4th, 2020, the issue of a severance of the trial of Defendant McDavid and possibly Defendant Brown was raised. The issues raised above relating to witnesses, availability, and jury selection apply equally to a trial of these co-defendants because of the large overlap in evidence and witnesses, including the testimony of multiple victims about their abuse and the playing of approximately 90 minutes of CP, which related to counts against both co-defendants, i.e. knowing receipt of CP, conspiracy to receive CP, and conspiracy to obstruct justice relating to CP. 90 minutes. Okay. For y'all that saw the original CP, how long was it? I mean, was it 90 minutes long, or is there something else going on here? Then the last one was the government has diligently prepared for trial and would otherwise be prepared to proceed on October 13th, 2020. And so they're basically saying that they're ready to go to trial, but because of COVID, and consideration of the witnesses, the alleged victims, and everybody else, the defendant not being able to prepare for trial, that they are okay with pushing this date out. The document does not contain any suggestions on when they expect the trial to take place, no recommended dates. Maybe that will be discussed on the August 18th status hearing. We'll have to wait and see, but I just wanted to bring this to you. It was a quick, short motion, nothing that required a lot of studying. It was straight to the point. They're basically saying due to COVID, they're not prepared to set up a courtroom, that's okay for social distancing, and that they have witnesses who cannot travel at this time because they have health conditions that make them more susceptible to COVID, or either they are taking care of someone who is susceptible to COVID or may already have COVID. So, Just wanted to bring this to you. Not really much to discuss because I think we all saw this coming. But if you do have any thoughts or opinions, leave them in the comments. Rate the video. Subscribe to the channel if you haven't done so already. And as always, I shall talk to you guys later. Bye-bye.